Okay, good afternoon, everyone. I think we're going to get started here. Thank you for joining us. This is a presentation about knowing your rights and making your plans as we navigate the healthcare system as LGBTQ people and estate plan. So just some logistics, you can click on the little button highlighted in red there to toggle the panelists' videos on and off. And questions will be taken at the end of each section of the webinar. Viewers may submit questions to the panel by using the Q&A feature at the bottom of your screen. A video recording of this webinar will be sent to all viewers shortly after the presentation concludes. And of course, on behalf of all of us at HRC, thank you for your continued support through this difficult time. So the first half of the webinar will be about healthcare rights by Tari and Robin. And the second half will cover estate planning by Jade and Elizabeth.
Thank you, Kendrick. So my name is Tari Hanneman. I'm the director of the Health and Aging Program. And if we can have the next slide, please. Well, no one wants to spend time in a hospital as a patient. If you do have to be hospitalized, when you are hospitalized, you want to be focusing on your health and getting better and not having to worry about discrimination. And so that's why the HRC has the Healthcare Equality Index, or the HEI, as you may refer to it. It's to help hospitals create welcoming and inclusive environments for their LGBTQ patients. So in the first section of our webinar today, Robin and I are going to talk about some of your rights as a patient in hospitals and how you can learn more about your patient non-discrimination rights and if your hospital has them. And I'm going to talk about these rights using the Healthcare Equality Index as kind of a background for some of the information that I'm going to be sharing. Last August, we launched the HEI 2019, which was the 12th edition of this important report. And it was actually launched in Columbus as part of Alfonso David's first tour at HRC. Next slide. So the Healthcare Equality Index was modeled after the successful Corporate Equality Index, which many of you may be familiar with. It was started in 2007 to create a national standard for the care of LGBTQ patients. Back then, as you can see from this, the original HEI, we had about 10 recommendations for improving care compared to over 50 or 60 that we look at now. These recommendations included 3 policies that we consider to be absolutely fundamental to be foundational to better care. That's having an LGBTQ inclusive patient non-discrimination policy, an equal visitation policy, and an LGBT inclusive employment non-discrimination policy. So we're going to focus on those first 2, the patient non-discrimination policy and the equal visitation policy, in the first part of this webinar, since that's what impacts you the most as a patient. And when we launched the HEI, there was no legislation, no governmental regulations or guidance that helped facilitate these 3 policy recommendations. So we were really setting the standard at HRC by setting these benchmarks. And while there has been tremendous progress over the years since we launched the HEI in LGBTQ equality, only one of those 3 policies is still is a law or regulation even today. And that's the equal visitation policy, which you'll hear about a little bit later. Next slide. So there are no broad national, federal, explicit non-discrimination protections for LGBTQ people, which is why HRC is leading the fight for passage of the Equality Act. Since there's no explicit federal laws, similar to other non-discrimination protections, we must rely on a patchwork of state or city laws or other regulations to guarantee our rights. So for patient non-discrimination laws, these typically fall under public accommodation laws. And you can see from this map from our state equality index that fewer than half of the states have public accommodation laws that are inclusive of LGBTQ people. You can also find that some cities will have these public accommodation laws with sexual orientation, gender identity protections. And you can find if your city has those laws by checking out our municipal equality index. Some states also have specific patient bill of rights and that include non-discrimination protections that are inclusive of sexual orientation and gender identity. Another way that this might be covered is through the hospital's accreditation. Accreditation is something that hospitals can choose to do. It is not a requirement, and they are accredited by independent agencies, not a governmental agency. Approximately 80% of the hospitals that are accredited by an agency called the Joint Commission. And the Joint Commission is actually goes beyond the federal law and does have a requirement, or a standard as they call it, that requires that hospitals do not discriminate based on sexual orientation and gender identity. The problem is that the Joint Commission does not really explicitly indicate how that standard is to be enforced. And so they don't require that a hospital have an inclusive, not written non-discrimination policy. So once again, the Healthcare Equality Index is really setting the standard. We require that hospitals have a written non-discrimination policy that includes both sexual orientation and gender identity, and that they communicate that policy publicly in at least 2 different ways, and to their staff in at least 1 way. You can have the next slide. So this is just kind of a snapshot of the healthcare facilities that participated in the HEI last year, the HEI 2019. You can see that we had healthcare facilities from all over the country participating. We have, we work with over 120 different nonprofit and for-profit and public health systems, all different types and sizes of hospitals. This is a tool and resource that grows every single year. So last year we had 680 participants. This year in the HEI 2020, which we are currently working on now and which will be released later this summer, we will have over 760 participants. So we continue to grow and build a network of hospitals that have fully inclusive, affirming policies and practices in place. And the hospitals that receive our top score get this LGBTQ Leader in Healthcare Equality Index designation. And last year, 408 or 60% of our participants received that designation. And the next slide, please. So again, like I mentioned, to meet our requirements, a patient non-discrimination policy has to have both sexual orientation and gender identity in the enumerated list of protected classes. So this is just an example of a very simple patient non-discrimination statement. This is from St. Luke's Health System in Kansas City, Missouri. And I just want to note that Missouri is one of those states that does not have explicit protections for sexual orientation and gender identity in public accommodations or much else. So that is why the work of the HRC Foundation is really critically important, to be working with institutions of everyday living like hospitals, corporations, etc., to help them provide these non-discrimination protections when the state isn't going to do that. But in addition to the healthcare facilities that participate in the Healthcare Equality Index, we, because it is something that hospitals opt into, it is totally voluntary, but because we also want to see how the rest of the country is doing and how other hospitals are doing, we've done research on over 1,000 other hospitals around the country to determine if they have an inclusive patient non-discrimination policy. And while not all hospitals put their policies online or responded to our request to receive their policies, of those where we found policies that were enumerated, only 67% out of nearly 1,000 hospitals had inclusive policies that were inclusive of sexual orientation and gender identity. So again, just points to the important work of the Healthcare Equality Index to get these hospitals on board with fully inclusive policies. So if I can have the next slide. So what we want you to know is how you can find out if your hospital, your local hospital or healthcare facility has these policies. So obviously the first place to look is the Healthcare Equality Index. We have both a state search feature as well as a interactive Google map that you can look at. But that's going to have probably about 1,700 hospitals around the country. There's closer to about 4,000 hospitals So we don't have everyone covered. So take a look at there first. If you don't find your hospital, then I recommend checking out their website and looking for some of these terms like patient bill of rights, patients' rights and responsibilities, non-discrimination, patient and visitor information. Some of the better hospital websites will have that in a really easy, visible way for you to find it in their menu. And some you have to do kind of deeper searches, but this is something we encourage you to look for and think about before you have to go to a hospital. When you do go to a hospital, they are required to give you your patient bill of rights when you check in. But again, hopefully you're not going to the hospital. We just are trying to prepare you for if you do have to do that. So now I'm going to turn it over to Robin to talk a little bit more about what federal protections actually do exist.
Yes, and great. And as Tori said, all of this is out of an abundance of caution. Hopefully you will not find yourself in the hospital in the next 6 months, but these are all really good tools to have at your disposal if you or a loved one ends up needing them. So as Tori mentioned, there are no federal explicit protections in healthcare for folks. However, there are protections, and we definitely want you to know that you do have rights when you walk in the door of any healthcare facility, including hospitals. And one of the best tools you actually do still have is Section 1557 of the Affordable Care Act. And Section 1557 of the ACA prohibits discrimination on a series of factors, including sex. And that includes sexual orientation and gender identity based on the courts. And as some folks might know, the Trump administration has worked to undermine these rights through removing regulations and refusing to support them in court. However, what we do like to say is that the Trump administration can undermine the statute, but the Trump administration cannot actually undo the rights that you have under the Affordable Care Act. You also have rights under the Americans with Disabilities Act, which prohibits discrimination on the basis of disability, including HIV status. And finally, also what might come up in the next 6 months or a year, depending on who you are, the Federal Nursing Home Reform Act also has a very baseline level of protections in long-term care settings. And this includes LGBTQ residents. And includes respect for LGBTQ residents and delivery of services. Next slide. So what to do if you do face discrimination or a hostile environment. As Tari mentioned, the hospitals have in place usually really good grievance processes. So file your grievance process. The Joint Commission is also a great resource because they want to be able to guide hospitals to do the right thing. And they are a great resource to go to. Your state also has a hospital licensing division as well as a long-term care ombudsman. And what these folks can do for you is really help hold your hand through any sort of complaint process and investigate it for you. It's their entire job. So if you experience discrimination, all states have these, and you can seek help there. And as Tari mentioned, many states have public accommodations laws that cover healthcare, and so you would be covered under those provisions. The Department of Health and Human Services Office of Civil Rights, as I said, unfortunately, is not the defender of our rights that it used to be maybe 4 years ago. However, what we would encourage you to go ahead and file a complaint with this office to go ahead and get it on the record, and in case you choose to move forward. Many courts have also interpreted the ACA to include sexual orientation and gender identity discrimination. And so if you experience injurious discrimination because of that, many courts have found for plaintiffs. And next slide. So I know that Jade and Elizabeth are going to cover this in their portion, but we did want to quickly cover the rights of same-sex partners and LGBTQ families to visit their loved ones if they become, if they're hospitalized or become incapacitated. And as Ty mentioned, the one area that we do have concrete regulations and concrete laws is equal visitation. And this is actually any hospital participating in Medicare and Medicaid, which is really very, I would say almost all of them, are bound by conditions of participation. And one of these includes respecting the designated visitors and decision makers that patients put in their documents, which I know Jade and Elizabeth are going to cover. And this came from, you can advance this slide a little bit. This came in 2011 as a result of a very tragic story actually out of Florida. Janice Langbein was denied access to her partner, Lisa Pond, who they had been together for many, many years, and they had several children together. And Lisa actually had a severe medical event while getting ready to go on a cruise. She was taken to a hospital in Florida when she was conscious, but Janice Langbein was informed by the nurse that this is an anti-gay county and an anti-gay state. And although she had all of her documents, she was denied access to Lisa, and her children were denied access to her. And she did not get to see her while she was awake, and she passed away. So President Obama, and Janice Langbein actually, she's such a hero. She actually has received the Medal of Honor from President Obama, and was really a leader on getting this done and getting this concretized into the Federal Register. And because of that, you have a right to be visited by or not visited by. You can actually put in who you don't want to see you into your documents. What I would say, the caveat here, is that these are unusual times. And because of the spread of the pandemic, many hospitals are cutting back on visitors altogether. And so if a hospital is not allowing visitors in a non-discriminatory way, meaning no one can have a visitor, you can't have a visitor. But in usual circumstances, you should be able to. I think next slide. And then I would add, and I know that Jade and Elizabeth are going to cover this in their piece as well, that advanced directives can also include, which they're going to cover at length, can include directions for your healthcare providers on gender identity and expression as well. And so I know that they're going to get into that, but that's a very good place to put in all of your wishes and how you would like to receive your medical care while you are hospitalized. So now, any questions at this point?
Okay, well, you can always enter questions in the Q&A box. And if you don't have any questions now, we can take them later, and we can move on to Jade and Elizabeth's portion.
Great, thank you so much, Robin and Tari. That was really wonderful and informative. I hope everyone learned something new. So my name is Jade Verity. I'm the Director of Estate Planning here at HRC. My pronouns are she, her, and hers. And next up, we are going to be talking about some important topics related to preparing estate planning that will help you communicate your wishes to medical providers and also to your loved ones. I'm sure it won't surprise anyone to learn that there's been a huge increase in the number of people completing wills and trusts and powers of attorney in the last month or so. Having a plan in place can be a really proactive and empowering thing to do during a time of crisis or uncertainty like the one we're currently in. And my hope is that the topics we discuss today will give you the information and tools that you need to take the next steps in completing your own estate plan or helping a loved one complete their estate plan. So now I'm very happy to introduce Elizabeth Schlesinger, who is a trust and estates attorney with the law firm of Bryan Cave in St. Louis, Missouri. And she's also the chair of HRC's Board of Governors. She's a tireless volunteer in the fight for LGBTQ equality. And in just a moment, she'll be covering some of the basics of the estate planning process, and we'll also have plenty of time at the end for Q&A. Please go ahead and submit a question at any point using the Q&A feature on your screen, and we will answer them all at the end. Thank you, and go ahead, Elizabeth.
Hi, everyone. Welcome. Thank you for being here today. So before we get started, I am ethically obligated to tell you that I am providing this webinar for educational purposes only, and that anyone with specific issues or questions should consult a lawyer other than me during the Q&A at the end. As Jade mentioned, my name is Elizabeth Schlesinger, and I'm an estate planning attorney with Bryan Cave Leighton Paisner in St. Louis, Missouri. I'm also the chair of HRC's National Board of Governors, a group of about 150 volunteer leaders from more than 30 communities around the country. I started volunteering with HRC in 2012, and since then I've gotten to participate as the organization has been at the forefront of historic wins and deeply challenging times for the LGBTQ community. Relationship recognition has been a key component of HRC's work at the federal, state, and municipal level, as many aspects of our law and culture relate to formal definitions of family. Many estate planning practices rely on these formalistic definitions, which even with marriage equality may not be appropriate for the LGBTQ community and our families, whether blood relatives or chosen. It's especially important for us to have our wishes clearly stated. Can we go to the next slide? A lot of people don't think they need an estate plan. Some people don't think they have enough assets to make it worth it. Some people expect it to be easy and assume their family members will be able to handle things. And some people know it's going to be complicated and they don't want to deal with it for that reason. None of these are good strategies. No matter who you are, what your family situation is, and what kind of assets you have, you need some kind of estate plan. It's especially important for members of the LGBTQ community to have an estate plan that clearly states their wishes. Next slide, please. As we know, due to health and economic disparities, the LGBTQ community faces unique risks associated with the COVID-19 pandemic. A comprehensive estate plan will go beyond directing the distribution of your assets, i.e., who gets what. It will also establish decision makers for both financial and medical purposes in the event of your incapacity. We call that who decides what. So in this presentation, we'll talk about decision makers in the event of your incapacity, how assets are transferred at death, and some practical estate planning tips for you to consider. If you become incapacitated without an estate plan, state law will determine who makes decisions for you. And if you die without an estate plan, state law likewise determines how your assets are distributed. All 50 states have different laws that govern this process, and all rely on formalistic definitions of family and next of kin. If you are not legally married, this could mean that a parent or sibling would have the right to make decisions for you and inherit from you, rather than a long-term partner. The map on this slide is especially relevant. Only the light blue and dark blue shaded states have comprehensive non-discrimination protections for LGBTQ folks. If you're part of the majority of Americans living in the majority of states shaded gray, you're at even greater risk, as your state law explicitly fails to recognize and protect you. Even if your state has default rules that would result in appropriate decision makers and beneficiaries for you, you still need an estate plan. Relying on the default rules always means the involvement of your county probate court. This can be a timely process under ordinary circumstances, and many courts are closed to all non-emergency proceedings at this time. Having a clear estate plan in place is the best strategy. So first, we'll talk about documents that establish decision makers in the event of your incapacity. Through estate planning documents called powers of attorney, you can designate people to handle your financial and healthcare matters in the event that you become incapacitated. In a financial power of attorney, which is sometimes called a durable power of attorney, you can designate an attorney in fact or an agent to handle financial matters for you. In most jurisdictions, you can choose whether you would like your agent's power to act on your behalf to become effective immediately or only in the event that you are not able to make decisions for yourself. Some people like their power to become effective immediately upon signing. For example, if they travel often and are hard to reach, if they completely share finances with a spouse or significant other, or if they're elderly and have their children involved in their finances already. Other people prefer their power of attorney to become effective only if they become incapacitated. This is helpful because you retain complete control during your lifetime and while you have capacity. But it is necessary for a physician to certify your incapacity for the power of attorney to become effective. Requiring a certification from a physician can sometimes result in a delay in your agent's ability to start making decisions on your behalf, so these options should be considered carefully. Through a power of attorney, your agent can do things like write checks out of your account, buy or sell assets, including real estate, access a safe deposit box, and make gifts on your behalf. But your agent is expected to act as you would with your assets. They can't just spend the money however they want. In many states, a durable power of attorney must be in writing. In some cases, it must be signed by 2 witnesses who are not related to you or named in your estate plan. And in some cases, it must be notarized. The agent you designate in your durable power of attorney can only make certain financial and legal decisions for you. They can't make medical decisions on your behalf. For that, you need a different document, which is sometimes called a healthcare power of attorney, or you may sometimes hear it referred to as a medical directive, advance directive, or a living will. For all purposes today, I'll be using the term healthcare power of attorney. In a healthcare power of attorney, you can designate an agent or attorney, in fact, to make healthcare decisions for you. Next slide, please. Thanks. Unlike with a durable power of attorney, all healthcare powers of attorney can only take effect after you are incapacitated and are unable to make medical decisions for yourself. In a healthcare power of attorney, you can give your agent guidance about what your wishes would be in an end-of-life situation. For example, keep me alive even if it involves feeding tubes or a ventilator, do not resuscitate me or administer any heroic measures, or something in between. You can also direct your agent regarding your wishes on organ donation and how you would like your remains to be treated, such as burial, cremation, etc. Just like with a durable power of attorney, a healthcare power of attorney must be in writing, and depending on your state law, it may need to be signed by 2 witnesses who are not named in your estate plan or related to you, and notarized as well. Now we'll talk about the distribution of your assets at your death. There are 4 main ways to control how assets pass upon your death, and they can be used individually and in combination: a will, a trust, beneficiary designations, and joint ownership. A will is a document that can accomplish 3 things. It can direct who will receive which of your assets at death. It can appoint an individual or bank known as a personal representative or executor to oversee that process. And it can also give your recommendation for guardians for children if you die when you have minor children. The process by which assets are transferred under a will is called probate, and it is overseen by the probate court in each county. There are strict rules governing how a will can be made because it is such an important document. In order to make a will, you must be 18 and of sound mind. In many states, your signature must be witnessed by 2 people who are not named in your estate plan or related to you, and your will should be notarized. You should sign only one of your original will and keep it in a safe place. A trust is an agreement that manages your assets during your lifetime and upon your death. There are many different types of trusts that accomplish different goals, but the most common type, and the one that I'll be talking about today, is a revocable living trust. A revocable living trust has several benefits. First, assets in your trust can be distributed without having to go through the probate process at your death. Second, the assets may be protected from being taken by the creditors of your beneficiaries. Under a revocable living trust, a trustee is designated to manage and, if necessary, distribute your assets. During your lifetime, you can be the trustee of your trust and manage your assets just as you would as if they weren't in a trust. You'll need to designate a successor trustee and preferably one or more backups who can manage and distribute your assets according to the terms of the trust after your death. Choosing a successor trustee and one or more backups is an important decision and one that you should give careful consideration. After your death, the trust could direct your assets to be distributed outright to the beneficiaries you select, or they could be held in trust and invested, and the beneficiaries could receive the income and dividends generated. Now let's look at how to transfer certain types of property without a will or trust. Any asset that has a title, like a house, a car, a bank account, life insurance policy, or retirement account, can be transferred without a trust or will if you complete the appropriate beneficiary designation. You can establish beneficiary designations for your life insurance or retirement plan proceeds by completing a simple form available from your retirement plan administrator or your life insurance company. The rules governing retirement plan distributions are complicated, and retirement plan assets are best used when made payable to a spouse or a qualified charity. Additionally, banks and brokerage institutions will allow you to designate a pay on death or POD beneficiary. This allows you to transfer your accounts without a will or trust. Next, we'll talk about how to implement an estate plan. If you own a car, there's a space on the title for a TOD or transfer on death beneficiary that you can update at the DMV. Some states allow for beneficiary deeds by which you can designate the owner of real estate following your death. This deed must be signed by you, and it will need to be notarized and filed in the appropriate county. If you sell the property, the deed would automatically become void. Some people think that they can avoid the need for estate planning simply by naming another person as the joint owner of their assets, such as adding the name of a loved one to their bank account, house title, etc. It's true that joint ownership can pass ownership to someone without the need for that asset to pass under your will or through your trust. However, this should be done in consultation with an attorney because there can be serious tax consequences to adding someone as a joint owner of your property. I hope this brief overview of the different ways to transfer assets through wills, trusts, and beneficiary designations has helped you understand that there are many options available. Choosing the right option should be done by consulting with an attorney who is experienced in this area of the law. As we've discussed with each estate planning instrument, each state has its own formalities with regard to the requirements to validly execute estate planning documents. The general rule has been that any document dealing with real property must be notarized, and many states require 2 witnesses to make any document valid as well. In this time of social distancing, nearly all states have adopted remote versions of these requirements. For example, allowing for witnessing by video conference and/or remote notarization. These new requirements are rolling out rapidly, and you'll be able to determine the steps needed in your own state and execute estate planning documents with the necessary formalities. My firm has created a tool linked in that slide to the execution requirements of each state, as well as any exceptions due to social distancing. I'd like to leave you with a word about doing your estate planning in the midst of a crisis, like the COVID-19 pandemic. I think it's great that there have been so many more people interested in completing their estate plans recently, and I encourage everyone to have a plan in place. If you find that you need to complete your estate planning documents in a hurry and are considering not using an attorney to help you, I would encourage you to have your documents reviewed by an attorney when things have stabilized a bit. A plan that you make during a moment of crisis can still be a good plan, but it should be seen as temporary to get you through until something else can be put in place. Thank you so much for your time today. I will now turn it over to Jade Verity, HRC's Director of Estate Planning, who will tell you more about some estate planning resources that are available to help you make your plan. After that, we'll be happy to answer any questions, so please go ahead and submit your questions at any time to get them in the queue. You can submit a question by using the chat feature.
Thank you so much, Elizabeth. All right, so now I'm going to tell you a little bit more about some resources that are available to help you do your planning. These are just meant to be practical ideas. It's certainly not an exhaustive list, but this can hopefully help get you started. I also want to encourage you to go ahead and use your Q&A button to submit questions now so that we can start answering questions as soon as we're through this part of the presentation. So if you want to use a lawyer to help with your estate planning documents, we have a couple of resources to help you find LGBTQ friendly attorneys in your area. First, if you'd like to work with a large firm, you can check out their scores on HRC's Corporate Equality Index. Firms with a score of 100, like Elizabeth's firm, Bryan Cave, have demonstrated their commitment to LGBTQ equality and inclusion. Or if you'd like help finding a small firm or solo practitioner in your area, you can contact me directly for assistance. If you use an attorney to complete your estate plan, we'd love for you to drop us a line and let us know how your experience was. We're always interested in hearing about experiences that our community has with attorneys so that we can keep that in mind when others reach out to us to ask for recommendations or opinions. Next slide. Oh, sorry, you're there. The next section I want to talk about is DIY document production software online. So as attorneys, Elizabeth and I are both partial to the idea that people consult with an attorney about their estate planning needs. Everyone's situation is different and unique. And what an attorney can really provide value on is providing you with professional advice about your specific situation. However, we also understand that some people are just more comfortable using online estate planning software to create their plans, especially during crises like the one we're currently in, when making an appointment with an attorney may just feel more difficult. So with that in mind, I'm very happy that one of the online will writing platforms, trustandwill.com, has generously offered to give HRC members a 20% discount off their products, which are actually already pretty reasonably priced. And the way it works is that you create an account on their site, you answer some basic questions about yourself and your family members, and then their software leads you through a series of more specific questions. It's very similar to TurboTax. I actually went through and used it myself just to check it out. And it was very intuitive in how it is in the platform and how it's presented and the questions that it asks you. And then once you're through that series of questions, you complete your documents, you pay, and then you can download your documents right away, or trustandwill.com will print out your documents and mail them to you if you would prefer. When you check out, enter the code EQUALITY to get a 20% discount. Also, if any of you are a healthcare provider or have a loved one who is a healthcare provider, Trust and Will is offering a free will-based estate plan. If you're a healthcare worker, you can go to trustandwill.com/frontline-heroes to verify your credentials and get your code for a free estate plan. And of course, when using any online estate planning software, you need to make sure that you carefully and accurately follow your state's laws with regard to executing your documents to ensure that your estate plan is legally valid. Every state has also adopted statutory living will forms. So this just means that if you use the form that your state has created and you follow the rules about signing it, the number of witnesses, et cetera, then you can be sure that it's a legally valid document that you can give to your healthcare providers. If you use an attorney or even many of the online estate planning programs, you're probably going to get a more robust and personalized document. But if you need something fast and free to express your wishes about your medical treatment and who should make decisions for you, these forms do exist. They can be a little challenging to find, but I found a pretty good site that I'll point you to. So you can find the form for your state by going to livingwillforms.org, but be careful on this site because if you click on the button that says Create Document, it will take you to a paid site called eforms.com. So scroll past that, and then you're going to see a list of all the states. Simply click on your state, and again, you have to ignore the Create Document button. And instead, you scroll to the bottom of that page and you click on Download a PDF of your state's document. And then it will simply bring up an Adobe PDF version that you can fill out online and then print. HRC also has some great estate planning resources available. If you go to myplanwithhrc.org, you'll find basic information on estate planning, and you can also download our complimentary planning guides. You can also find my contact information on that page if you need to get in touch with me. And you can also click on the link that says HRC Equality Circle if you'd like to notify us that you've included a gift to HRC in your estate plan and activate your Equality Circle membership. Finally, our estate planning department would really love to be a resource for you if you have any questions about estate planning. Many of our supporters have chosen to make a gift to HRC through their estate plans, which, if you're looking for a simple way to support HRC, may feel like a really comfortable way to give right now since it doesn't cost you anything. We're happy to answer questions about how you leave a gift to HRC through your will or trust or by beneficiary designation. But if that's not something you're interested in, we are still here as a resource for you. And I want you to feel free to call and ask any questions you have without any obligation or pressure at all. We'd love to help in any way we can. So that brings us to the end of our presentation, and we're going to have some time for Q&A. So if you haven't yet submitted your question, now is the time. Go ahead and click on that Q&A button on your screen and send a question to any of the presenters who have spoken today. So we will just wait just a minute to see if any questions come in. I'm sure there are some questions out there. Okay, so I'm not seeing any questions come in, which is fine. Hopefully that means we answered all your questions. I really want to thank all of you who took the time to be with us today for these important conversations about knowing your rights and making your plans. And a special thank you to our presenters, Tari, Robin, and Elizabeth, for bringing us so much great information. I know there was a lot of information here. If you'd like to listen to the webinar again, or if you would like to send it to someone who didn't have a chance to join us today, a recording will be posted on the HRC COVID-19 resource page, which is hrc.org/campaigns/COVID-19. Thank you all so much. Please stay safe and healthy. Take care.